Morning, everyone.
Good morning, Your Honor.
Hold on a second. I'm making sure I have the right calendars. Hold on 1 second. Give me 2 seconds and we'll get started. Good morning, ladies and gentlemen. I'm Judge Regina Mincy. We're going to start our state all-purpose calendar. Deputies, who do we have first?
Good morning, Your Honor. We have position number 1, Mr. Quentin Dennis, position 1.
Okay.
And this is on the VOP calendar. I know Mr. Walker got excited.
Huh? Oh, okay. I'm sorry. I'll turn my camera off.
My apologies.
And this is the which calendar?
The probation revocation calendar.
And you said the last name is Bennett?
Dennis, Quentin Dennis.
Hold on a second. I only have,
It was an updated version.
Yeah.
was there an add-on?
It was an updated calendar, Your Honor.
Ms. Grace, what'd you send me? I only have,
Yes, Judge, you should have it along with the competency calendar, that DV calendar, and the probation revocation.
look at the probation revocation that you sent me. I may just let you announce and read it so that we can get started, but I don't have that one.
Yes, you have the wrong, we're sending it now, Judge.
Okay. I will take the blame, but I didn't see it. If you want, Ms. Grace, you can go ahead and announce that case. Give me the case number, the defendant's name, charge, and then I see probation is on.
Okay, Judge, you ready?
Email is moving a little slow this morning. Yes, go ahead.
It's Quentin Dennis, case number 18 Ciara 005862, the letter E. The charge is battery, family violence, first offense, theft by taking.
All right. And I see probation is on. Good morning.
Yes, good morning, Your Honor.
Good morning. And what do we have with Mr. Dennis?
Yes, Your Honor. Mr. Dennis was sentenced on July 29th, 2019 to 12 months to complete drug screens and the Family Violence Intervention Program. As of today, Mr. Dennis has not reported to our office, provided proof of classes, drug screens, and he also got another charge back in 2019 of theft by receiving on October 27, 2019. His case has 4 months and 5 days remaining, and probation recommendation is to revoke his remaining balance.
All right. Free trial,
Yes, Judge.
what do we have for his history?
He does have history in Georgia beginning in 2008. So he has 17 arrest cycles in Georgia beginning in 2008. Within the last 10 years, he does have a willful obstruction law enforcement officer out of Fulton County. His position on that is August 2019. His last arrest was in Fulton County July 14th, 2023 for theft by taking. He has at least two FTAs and two violations of probation. And he also has a history out of Texas with one arrest that resulted in a misdemeanor conviction for assault causing bodily injury family member. That disposition was March of 2015. Nothing to add.
All right. Mr. Doe, this is your client.
Yes, Your Honor. Sorry, apologies, I was on mute. Yes, Your Honor. Good morning.
Good morning.
Yes, I spoke with Mr. Dennis yesterday and learned that he initially did report after closing out the underlying case. Shortly after, in the fall of 2019, his mom's house burnt down after that initial probation meeting and really just threw his life into disarray. And he failed to appear and do the conditions that were asked of him. Since that time, he's on more steady ground. I spoke to mom. She does have a stable address, which she gave me, and I'll provide an updated contact sheet with probation if necessary, as well as a contact number. Mom has a new business, Trap Kitchen, and Mr. Dennis has a job waiting for him, helping out with cooking upon his release. At this time, Your Honor, after speaking with Mr. Dennis and understanding he will be on his feet on release, we would ask either probation be reinstated as he does have 4 months left. That's not enough time to do the FVIP program, which takes 24 weeks. We would ask that to be converted to anger management so that Mr. Dennis can complete that. In total, Mr. Dennis has served 146 days in jail on this charge as well. So if it is revoked, we would just ask it to be time served. But if Your Honor is inclined to let Mr. Dennis complete probation for the 4 months and 5 days remaining, we would ask that he be allowed to do so with those classes switched to anger management so that he can complete them in time.
I don't know about converting the FVIP to anger management. Because that underlying charge was that battery family violence. And I know it is a long time. I know it costs, but there are some positives of that. So that hopefully we will not see Mr. Dennis again. And with the 4 months and 5 days left, and I don't know that probation had him reporting at all. You said he reported once?
My understanding was that he made initial contact, and then after the fire is when the contact ceased.
And I wished he'd have contacted probation to let them know about the fire. Then they could have made some arrangements for him. And the fire was in 2019. And then this is 2023. And we still haven't heard from him until now. How long has he been in now? When was he picked up?
My understanding is the middle of January.
Middle of January. Well, he's got a little history. He's got some FTAs too. Violations of probation.
He was arrested January 14th, Your Honor.
Thank you. And he has a job waiting on him with the mom's business. Is that correct?
Yes, Your Honor. He will also be living with mom. I confirmed her address now that she has a new home and is back on her feet. She's going to welcome her son back in and make sure that he stays on track.
How old is Mr. Dennis?
How old are you, Mr. Dennis?
32.
32 years old.
Children?
It's 12.
Twins? How old?
No, I got 12 kids, young.
Oh, you said 12.
Yes, ma'am. 6 girls, 6 boys.
Wow. You need to get out to start working to pay child support, huh?
Yeah, ma'am.
All right, I will not revoke you today. I'm gonna give you a shot. Give you a chance.
I sure appreciate it, young.
So hopefully we will not see you again here.
Yeah, you want.
And when they mean report, they mean report. I don't care what happens in your life, whatever it is, how terrible it is. You need to talk to probation so that they can know what's going on. They may even be able to provide some suggestions and resources, and certainly keep up with your attorney as well, so that when other things go on in your life, you can still, handle everything as best as you can. So I will not revoke you, but this will be your last chance at getting it together. I am not going to convert FBIP to anger management. I want you to complete that FBIP. Once you start, you got to keep going for those, I believe it's 24 weeks.
Yes, ma'am.
Okay, and it's good therapy for you. So good luck to you.
Thank you.
Thank you, Your Honor. And I'll provide Mr. Dennis with the number and address of probation. If he knows that's the first number to call on release.
Okay. All right, thank you.
Thank you a lot, young.
Uh-huh.
And I'll send that petition shortly, Ms. Harris. And Your Honor, regarding the probation revocation calendar, while we're on it, while Ms. Harris is on,
Uh-huh.
the other position, Antoine Russell, for positions 2 and 3, we've learned
Right.
that he's being held in Oconee County, and he's not going to appear today. We were not aware of that. We didn't request a transfer in time or to make sure he would appear. So we would ask for a reset. We can address that now or later, but while Ms. Harris was here, I wanted to make sure she heard that.
Right, I'm looking at a message that I have. He won't be getting released till he closes out his case there. So it's gonna have to be further notice till we know that he's out. I don't think he's going to be out next week, if that's what I,
So that was on the previous case. Sorry.
yeah, what you got, Mr. Jordan?
So Quentin Dennis, he has a felony hold. He has, he's holding on case 19 SC 173957, and he has a $6,000 surety hold on that. And he also has a new case, 23 SC 186115. So I just want everybody to know that he's not getting released from jail. He has $10,000 fine on the other case. So he has to post a $16,000 fine just to get released. So,
Just to, right,
Right, and the family is aware, Mr. Dennis is aware that this issue was no bond status, which is why we wanted to resolve it. My understanding is he will hopefully bond out soon, now that there's no bond, or there will be a resolution with the felony attorney shortly. But he does understand as soon as he's released that he needs to report.
okay. All right. Does that close out this matter for us today?
That concludes my business, Your Honor.
Oh, you don't have any other cases with me today?
No, Your Honor.
All right, I will see you next time. Thank you.
And where are you, Your Honor, so I can have you sign off on Mr. Dennis' paperwork?
You will have to give it to, go to the second floor so that they can scan it to me.
Okay.
There's a different judge in G33. Miss Grace, where do you want her to come? Or Miss Champion?
She can come to J150 and just ask for me.
Okay.
And
All
I'm,
right, that concludes my business, Your Honor. May I be excused?
Yes, you may. Thank you.
Thank
Have a
you.
good one.
and
Okay.
too.
I'm scanning that right now, okay? So you won't have
Okay,
to
thank you.
too long.
Position 24 and
One second,
25.
one
Mr.
second,
Tartt.
Doctor, one second, one second.
All right,
This is gonna be position 31. Ms. Wright, you go after this, Duffy.
Okay,
all right.
This is a negotiated plea. It was marked earlier as to be announced, and we have met her, talked with her. She wishes this to be a negotiated plea, Your Honor.
okay. This is Latasha Wright.
Correct.
Okay, case number 23 CR 0024538. And I understand this is a negotiated plea.
Yes, Your Honor. The state's offer involves 16 extra jail days and an FVIP. She and I have discussed what those mean. And there's no contact with Charles someone, and there's stay away from a certain address.
What is Charles's last name again?
It's Rollins.
I think it's Rollins.
Yes, it's Rollins.
Oh, okay. All right, go ahead, state.
Yes, Your Honor. Good morning. The
Good morning.
state's offer is 12 months to serve 60 days, credit for time served 14 days. The balance probated to a FBIB course, and no further contact with Mr. Charles Rollins, as well as to stay away from 149 Alabama Street.
That is her understanding of the terms, Your Honor. She asked the court to accept her negotiated plea as she stipulates to venue, jurisdiction, of course, venue, factual basis, and identification.
All right, good. Raise your right hand for me, Ms. Wright. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right. I want to ask you a series of questions in order to accept your negotiated plea to make sure you understand what you're doing. First question is, are you under the influence of any medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes.
And do you understand that by pleading guilty, you're giving up and waiving your right to the presumption of innocence?
Yes.
And that you're giving up and waiving your right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And you are prepared and agree to waive these rights today, is that correct?
Yes.
Has anyone told you will receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And do you understand that if you're currently on probation, your probation may be revoked or affected by this guilty plea here today?
No.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
All right, and I will accept your guilty plea to 1 count of battery, family violence. You've heard your conditions, and that will conclude the plea. Is that correct? Any questions on the conditions
No, ma'am.
or terms of your probation?
No,
All
ma'am.
right,
Your Honor, financially, of course, we would ask the court to consider giving her a financial break on the probation fees for a certain number of months, because that is a 5.5-month long course that will be rather expensive.
how old is Miss Wright?
32.
32. I will not be able to waive any probation fees. I don't know if the state would object to her going non-reporting once she's finished her FVIP.
No objection from the state.
Okay,
That does help. She does have another matter to go to, and hopefully that will be brief.
okay. All right, good luck to you, Ms. Wright.
Thank you.
Good luck, good to meet you. Take care.
Position 24 and 25. Mr. Tartt.
Mr. Tartt on jail court's iPhone. I
Oh,
spoke
okay.
I spoke with him, Your Honor, last evening, and I also met in person with his other attorney. This is a not guilty. We're going to waive the reading of the accusation, and ask the court to simply tell him what the maximum punishment is and to watch out for his court date.
All right, so we're going to do an arraignment. All right, is it Kristen Tart? I have two cases, 22 CR 006598G. And then I have another case ending in 2474D. We're arraigning on both.
Correct, Your Honor. One is I believe the FTA. And bond is moved, Your Honor, because of what the bond is in this other case.
All right, so the case ending in 6598D is one count of simple battery, family violence. And Mr. Tart, I just want to let you know that again, your attorney has waived the formal reading of the accusation, but this charge has already been formally accused by the Solicitor General's office in Fulton County. And this charge carries a maximum sentence of 1 year in jail or a maximum fine of $1,000. And that is for each of the charges. I see that your second case is battery, family violence, and then the first case is simple battery, family violence. Second case is battery, family violence. And both of those cases carry the same penalty. Again, these cases will be reset for jury trial for the notice by the division judge. And at your trial, you have the right to an attorney. You do not have the burden to prove these charges at trial. The state, represented by the Solicitor General, will bear that burden, and they will have to convince the jury beyond a reasonable doubt in order to get a conviction in the case. If they do get a conviction, again, you could face a sentence of up to 1 year on each of those charges in prison or a fine of $1,000. All right. So based on this information, how do you plead to both cases?
I was only talked about one case, Your Honor. I wasn't talked about the other case at all. I never talked about the other case at all.
It'll be the same principle, Mr. Tart. The thing is, the other case involves issues that if you were to plead guilty today, you would be affecting your other case probably. And I believe your decision was to plead not guilty today to misdemeanor court and have your felony lawyer look at everything and talk with me and talk with the state and move on and figure this whole thing out as an overall matter. We sometimes say global, sometimes we say global offer, but sometimes we say a global situation. We're trying to look out for you in an overall way, considering that you have more than one thing going on. So if you want to plead not guilty today, that would move the case on to the trial courtroom.
All right, you understand, Mr. Tart? I'm going to have you, okay, so we're going to make sure that you understand that you will plead not guilty in both cases. You've been formally arraigned and notified of the charges, and then your attorneys will be talking to you on a disposition at a later time, okay?
Yes, ma'am.
All right, all right. Thank you. That concludes your cases.
Next, Your Honor, we have position number 19, Mr.
Okay.
Deidre Martin.
This should be, this a non-negotiated plea?
Correct, Your Honor. The state was thinking some extra jail days, and I'd like to offer reasons why it would be justified to let him go to a rehab that he's trying to get into.
All right, let me call this case. This is 23 CR 002497J. Looks like it's Dedrick Martin, charged with one count of criminal trespass and damage to property, second count of criminal trespass, and then a third count of willful obstruction of a law enforcement officer. What do we have, state?
On mute.
Sorry about that. So yes, Your Honor. So this incident occurred April 21st, 2023 at 617 Elnor Place. And this is where Mr. Freddie Simmons came home to that address to see his window shattered and a metal security bar bent. And so when he went inside his house, he's also observed locks on the doors that were tampered with. He saw a lockbox that he had on one of the door, one of his doors, it was missing. And so when he continued to check his house out, he saw the defendant sleeping in one of his bedrooms. And so when Mr. Simmons told the defendant to leave, the defendant told him, you're gonna have to kill me, I'm not leaving. And so Mr. Simmons and the defendant, they got into an altercation to get Mr. Simmons out of the house. And then Mr. Simmons walked a couple of houses up the street to call the police at his daughter's house. After calling the police, Mr. Simmons was able to, and the police were able to locate the defendant, but the defendant did run from the police. And so Mr. Simmons and the police had to chase him where he was detained. And for those reasons, the state's offer is 12 months to serve 90 days, credit for time served 14 days. The balance probated to a BHET and to stay away from that address 617 Elnor Place, as well as no further contact with Mr. Simmons, as well as when Mr. Simmons gets us the amount of damage the defendant caused to pay the restitution on his window, the bent bar, and the lockbox.
You don't have that today?
No, ma'am. We're trying to get in contact to get that, but for right now, we do not have it.
If we don't have it, we can cancel the restitution.
Yeah, I was gonna say I can't complete my order. I can't go back and add restitution later.
Okay.
All right, Mr. McLean.
Yes.
Okay, I was looking there. I was like, make sure I'm not getting the name incorrect. Yes,
Right.
let's say Mr. McLean.
Your Honor, he's been in touch with the staff, the intake staff at Trinity House, which is a drug rehabilitation center. We're not necessarily in agreement with all the facts the state recited because he did no damage to the house, but he would like to plead guilty nonetheless, Your Honor, to the charges as charged today here in misdemeanor court in the state court of Fulton County. He would stipulate the 3 necessary elements. He understands what the state has offered, but the reason he wants to go unnegotiated is that this was a relapse situation. He didn't damage anything, but he says he does want to take the guilty plea. He was simply staying there. There's no indication of who the heck broke that stuff. But Trinity House has got a good reputation. Mr. Ali, who I think may have had a health problem, may not be, he may have an acting director right now. We've worked with him, the public defender's office worked with him through the years. They're at 21 Bell Street, which is an historic Atlanta structure. It's a former funeral home building, which figures in Atlanta's history. But they've been operating for decades as a drug rehab. They're high quality drug rehab, and he wishes to get into that and take part in their program. He has children that are 17 years old, 15 years old, and 9 years old. And he has, he's self-employed, and he drives a truck, I believe, right, delivers things. So instead of 31 or 30 extra days in jail, however it's calculated, we would ask the court to consider giving him time served as of today for the jail portion of the sentence, and a condition of continuing to apply to Trinity House and getting into that or something similar. He
Well,
says he's already been what now? He says he's already been accepted for outpatient.
Yeah, that's what I was going to ask.
That should solve the problem of, the reason for being in somebody's place was, being out where you're not supposed to be in. It was a relapse situation on it.
Right. And so the state was offering 12 months to serve 90 days credit for time served at 14 days. And the state was asking for service of how many more days?
Well, 90 divided by 2, assuming good time behavior of 2 for 1, 90 would be 45, 45 minus the 14 would be 31. So what we're asking the court to avoid for him is 31 extra jail days.
Okay. If he is for sure going there, I'm going to give him an opportunity at going to the Trinity House. So I will not make him serve the additional 31 days as long as he reports within 24 hours. Just about the same time he would probably be released from the Fulton County Jail to report to the Trinity House.
Right, and I don't mean to imply that he's going inpatient. It is outpatient.
That's fine. I understand. It's as long as he's reporting and complying with the outpatient treatment.
Listen to her, listen.
And there is no restitution because we do not have the amount or the facts on that. So it would just be, again, he's got to get a BHET. Stay away from that address, 617 Eleanor Place, and no further contact with Freddie Simmons. So whatever the BHET recommends, and I'm assuming that the Trinity House will obviously help him with that, then he must complete that form of treatment.
Right, the BHET should be fairly easy to obtain. It doesn't cost more than a couple $100 at the most, I would think. And it will be an evaluation. I think you'll be fine. If treatment is indicated, you'll be glad to get that treatment. Sounds like he probably does not need that, but that's up to the evaluator.
Okay. All right, I will, that's my ruling state. Are we ready to take the plea?
Your Honor, yes.
Okay.
Is that meant for the defendant?
Right, I was making sure. Since that's my ruling, we're ready to take the plea, Mr. McLean.
Yes, Your Honor. So that's the guilty plea that he's offering, and he stipulates to venue and factual basis and identification.
All right, raise your right hand for me, Mr. Martin. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, you put your hand down. Are you presently under the influence of any medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, Your Honor.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, Your Honor.
That you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, Your Honor.
That you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes, Your Honor.
And you are prepared and agree to waive these rights today, is that correct?
Yes, Your Honor.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
And has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you are presently on probation, your probation may be revoked or affected by a guilty plea today?
Yes, Your Honor.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, Your Honor.
All right, I will accept your guilty plea to the 3 charges. And you have heard the conditions, the terms of your probation. And once you complete those terms, then I will allow you to go non-reporting.
Yes, thank you, Your Honor.
All right, good luck to you.
Thank you. Thank you.
Judge, can you read out the served time for this defendant since they?
Okay, I'm gonna ask Ms. McLean to do the math for me. It's better. It was 12 months to serve 90 days. And so now he's getting credit for 45, Mr. McLean?
Right, credit for 45 would cause that to be time served as of today.
Okay. And then that balance probated with the BHET, the stay away, and no further contact. You have all that?
Yes, thank you.
Okay, thank you.
Wait a minute, I'm sorry to come in, but
Uh-oh, did I do the
I
math
don't-
wrong?
Mr. McLean, I don't think he served 45 days, correct?
Another way of doing it, I think the better way of doing it would be simply to take the 14 and double it and say,
Correct, because the judge's not gonna give him time for credit he didn't serve. So
Gotcha. So
The record room would be in rebellion.
Correct. We need to do 28, credit for time served 14.
Right, that'd be the way to do it.
Okay,
Okay, thank you.
Thank you, Mr. Walker.
thank you. All right.
Position 1 and 2.
Okay.
My representative today.
All right, position 1 is 20 CR 005262Y. Is it a dream? And second case is 23 FTA 000348. 2 counts of simple battery, 1 count of simple assault, and an FTA from November of 22. Original offense date is December 20th of 2018. What do we have, Mr. Dodas?
Thank you, Your Honor. For position 1, we are going to waive arraignment and enter a plea of not guilty. For position 2, I originally wrote request to set aside, but we don't need to address it. It's not what's holding him at this time. So I'll just submit that waiver and that should.
Okay,
By these 2 positions.
all right, that sounds good. Is it a dream? I'm mispronouncing your last name.
Adrine.
Oh, Adrine, I'm sorry. Thank you for that. All right, Mr. Adrine, I apologize. I am going to arraign you for your first case, ending in 5262Y. And I want you to again understand that the Fulton County Solicitor General's office has already accused this case. And the charge carries a maximum sentence of up to 1 year in jail and a maximum of a fine of $1,000 for each of those charges. So they could run consecutive or concurrent, whichever occurs at the time. Also, you are entitled to a jury trial. Of course, you will have a right to an attorney. And again, you do not have the burden to prove the charges at trial. The state has that burden, represented by the Solicitor General. And if they get a conviction, then again, you could face that sentence of up to 1 year and $1,000 fine on each of the 3 cases. So based on that information, how do you plead to the 2 counts of simple battery and the 1 count of simple assault?
Not guilty.
All right, we have that. Your case will be further noticed for trial. Right, thank you.
Thank you.
Next, Your Honor, we have position 5 and position 6, Mr. Brinson.
Okay. Are these going to be pleas or a plea and a no par?
That is correct, Your Honor.
Yes, Your Honor. I will also note, and if Mr. Jordan can provide some light on this, Mr. Brinson is the FTA. There's a second FTA under 23 PF 002788. That appears to be related, but it looks like accidentally filed in Superior Court. I don't see any underlying case, and there's no jailing for an underlying case. So I do want to make sure that this, what appears to be a mistaken Superior Court FTA number, won't keep holding Mr. Brinson.
You see that, Mr. Walker?
I see the PF that's holding him, but I think Mr. Jordan might have to answer that
Help
one.
us that. Okay. Mr. Jordan? Oh, or Miss Grace, you have to get Mr. Jordan. I don't know if he's still on with us. I don't
Just
know.
a moment.
Yeah, or Mr. Champion, if she's able to see it.
What did you need, Joe?
Yes, on position 6, 5 and 6, Mr. Brinson. There appears to be a 23, is it PF?
PF 002788.
That may have been filed in Superior Court in error.
So that was placed on the jail screen during booking by the jail. So they created that pre-file case number, but that it should have been our case. They booked them in on a felony failure to appear, but it was
Mhm.
should have been a misdemeanor failure to appear, which is our case.
So I
So
guess
the
my
warrant
question
listed next
is,
to it is the state court warrant. That 22-000-745 FTA is the state court warrant.
all right, so I guess I'm sorry to cut you off, but when I submit the null process with the FTA number with the records room in the jail, know that it's the same.
Yeah,
thing.
I'll talk to them. Put the 23 FTA 000349 on it. And I'll tell
Okay.
them they need to correct the jail screen.
Okay.
Okay, good.
Thank you, Mr. Jordan and Mr. Walker.
Thank you all for that. And so position 5 is a time served negotiated plea.
Yes, it's time served of 15 days, balance suspended to remain compliant with any MARTA suspensions.
Okay. Is that your understanding, Mr. Dotis?
Yes, Your Honor, that's my understanding.
Okay. All right. Now, are we ready to take this plea with Mr. Brinson?
I believe so, Your Honor.
All right, this is, I don't know if I called this case 22 CR, excuse me, 004062J. It's one count of fare evasion. That offense date is 11/24/2020. Mr. Brinson, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, I'm gonna ask you a series of questions in order to accept your guilty plea. The first one being, are you under the influence of any medication, drugs, or alcohol?
No.
Are you satisfied with the services and representation of your attorney?
Yes.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
You can put your hand down. And do you understand that by pleading guilty, you're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And you're prepared and agree to waive these rights today, is that correct?
Yes.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And do you understand that if you're currently on probation, your probation may be revoked or affected by your guilty plea here today?
Yes.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes.
And so as to the charge of fare evasion, how do you plead?
Yes.
All right. And so again, this is a time served plea of 15 days, balance suspended, and you're to comply with any and all MARTA suspensions. So you have to stay away during your suspension time, okay?
Yes.
All right. That will conclude this case.
Thank you, Your Honor.
All right, thank you.
We have position number 8, Mr. Tony Clark.
All right. And is this a non-negotiated plea?
Yes, Your Honor. Our only issue is the restitution amount.
All right, state, let me call it 23 CR 002456H, Tony Clark, 2 counts of theft by taking, offense date. Do we have 2 different offense dates, April 13th and April 14th of 2023?
That's my understanding, Your Honor.
Okay, and what else do you have, state?
So the state's recommendation is 12 months to serve, 34 days, credit for time served is 17 days, balance probated, an anti-theft course, a stay away from Georgia State University, and restitution in the amount to the victim whose name is Stephen Smith of $1,165. Just to give the court some background about this case, the victim, Stephen Smith, is a student at Georgia State University. His backpack was stolen at the Georgia State University Student Center. In his backpack, it contained his laptop along with some accessories along to his laptop. The amount of $1,165 is the amount that's listed in the warrant, and we are requesting that that amount is paid to the victim.
Right, Mr. Dotis?
Thank you, Your Honor. I don't have a legal basis for the restitution. It's not, I don't have, outside of the warrant, I don't have the value of the items. I will also note that the items are listed as totaling $1,165. But when I add up the math, I only get $1,115 on the values listed. Outside of this arrest affidavit, I don't have any values listed. It's not clear if the items were returned or if they were insured. So at this point in time, we would ask for no restitution and for this plea to go forward. If not, then we just ask for a restitution hearing at a later date and have this plea be allowed to go forward in the interim.
Mr. Walker, did you get any receipts or paperwork or anything?
No, I was using the information that's on the warrant, which is this warrant affidavit. If the math is wrong on the warrant and it totals 1,115, I can ask for that. But if the defense would like a restitution hearing, we can put it down for one. But the information that was presented in the warrant is what I'm presenting to the court. So, and it's itemized as to what was taken in each value.
I would tend to order that restitution, Mr. Dotis. I could move it down to the 1,115, but it seems to be pretty clear in the warrant, itemized in a sworn statement.
If I could have 1 second on mute to speak with my client.
Okay.
Thank you, Your Honor. We're prepared to go forward with the plea offer for the restitution of $1,115.
Okay. All right. Mr. Clark, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. I'm going to ask you a series of questions in order to accept your guilty plea. And put your hand down for me. And the first one being, are you presently under the influence of any drugs, alcohol, or medication?
No, Your Honor.
Are you satisfied with the services and representation of your attorney?
I am.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
I do.
And do you understand that by pleading guilty, you're giving up and waiving the right to remain silent and not testify against yourself?
I do.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
I do.
And are you prepared to agree to waive these rights today?
I am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes.
And so as to the two charges of theft by taking, how do you plead?
Guilty.
All right, I will accept your guilty plea. So you understand the terms. Any questions about that?
No.
Okay, all right. And so you understand that when you report to probation, they will explain to you about the restitution for the $1,115.
Yes.
Okay, all right.
And Your Honor,
Yes,
my apologies, I didn't mean to speak over you. We would request, if there's no objection, to allow Mr. Clark to switch to non-reporting status upon completion of the class and payment of the restitution. And if Your Honor would be so inclined to give Mr. Clark a break on a few months of probation fees, Mr. Clark will be residentially challenged upon release and wants to make sure that he's set up for success to take the class and pay off his restitution amount.
All right, what I'll do is I will waive 6 months of the fees. And I will allow him to go non-reporting after he has paid the restitution in full, as well as taken his anti-theft class. And just remember, while you're on probation, you are to stay away from Georgia State. That's a pretty vast area. And Mr. Walker, is it any and all Georgia State property?
That is correct, Your Honor.
It spans pretty far and wide through downtown. So if they see you on any property that has Georgia State on the door, or Georgia State, you're to stay away while you're on probation so that you aren't rearrested. All right?
Okay.
All right, thank you.
Next, we have position number 9, Mr. Brandon Clyburn.
Is this still a negotiated plea?
Yes, Your Honor, this is a negotiated plea. And I believe, one second, Your Honor, as an aside, I believe someone from the Patch Initiative is on the line as support for Mr. Clyburn, if that's my understanding. But this will be a negotiated plea.
Okay, I think I see someone.
I did want
Good
to
morning.
acknowledge.
Good morning, Your Honor. How you doing?
I'm fine. How are you?
I'm all right. Thanks for asking.
Okay. This is Mr. Brandon Clyburn, case number 23 CR 0024588H. He's charged with 1 count of criminal trespass. The offense date is April the 18th, 2023. State?
Yes, Your Honor. The state's recommendation is 12 months to serve, 34 days, credit for time served, 17 days. Balance suspended with the condition of a stay away of Castleberry Park, which is located at 60 Magnum Street, Atlanta, Georgia.
Magnum Street.
Yes, Your Honor.
Okay. And then this Castleberry, is it Castleberry? Is it shops? The apartments are just the.
I think it's an apartment complex, but the name is Castleberry Park.
Okay. All right. Mr. Dotis?
Yes, Your Honor. I believe this will be a negotiated plea. It seems like the spirit was time served. I would note that Mr. Clyburn only has credit for 16 days. So if we could word it as served 32, credit for 16 instead of the 34 days.
That's fine.
Okay, so
Okay.
that's what I would add. And then I would note that I believe it's 60 Mangum, Mangum Street. Unless I have that, I want to make sure we get the right street.
You're probably right.
That's my understanding of it. Other than that, we do stipulate to the factual basis, genuine ID for the purpose of this plea.
Okay. All right. Mr. Clyburn, are you ready and prepared to take a plea today?
Yes, ma'am, I am.
Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, I'm going to ask you a series of questions in order to accept your guilty plea. And just answer for me. The first one is, are you presently under the influence of any medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, I am, ma'am.
Do you understand that by pleading guilty today, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you are prepared and agree to waive these rights today, is that correct?
Yes, ma'am, I am.
And has anyone promised you anything to plead guilty?
No, ma'am.
Has anyone told you that you receive a lesser sentence for pleading guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be affected by this guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
All right, I will accept your plea to criminal trespass, and how do you plead?
Guilty.
All right. And so you understand we're going to change that, Ms. Grace, to serve 32 days, 12 months probation to serve 32, credit for time served at 16.
Yes, ma'am.
Okay. Balance suspended to stay away from Castleberry Park Apartments at 60 Magnum Street, or Mangum. I probably got it wrong too. And I know Ms. Grace will see it on the documentation to get the street right. So I also need to make sure Mr. Clyburn is being released or going into the PAD program.
That's my understanding.
All right.
Yeah, I'm sorry. I was waiting for someone from the pad, but yes, that's my understanding, Your Honor.
Yes, Mr. Is it Diamante?
Yes, ma'am.
Okay. What would you like to say to the court today?
I just wanted to advocate on behalf of Brandon. You know, I understand that he did plead guilty and he does have to, you know, serve the remaining of his time. I just ask that he be released to PAD, and then that way we can just work on, you know, combating the barriers that he have currently.
Well, that's what I have done. We've given him credit for time served, and he will be processed within 24 hours. And hopefully he will be successful with PAD and we won't see him again.
Definitely. I did just want to ask too, is it possible to get the contact information of his probation officer?
Yes, Mr. Dotis can give that to you, I think.
And just so we're clear, Mr. Clyburn will not be on probation for this charge.
Oh, that's right. I'm sorry. It's suspended.
Okay, cool.
Right.
So he will not be on probation.
Yeah, no other conditions for this case. He'll be released within 24 hours.
Right. All right. Good luck to you, Mr. Clyburn.
Thank you, Judge. I appreciate that and everybody involved. Thank you all.
All right.
I'm sorry, I did just have one question. So I'm a little
Yes.
confused. So like he'll be released tomorrow, or he has to stay for the remaining time to serve the days?
No, he will be released tomorrow, 24 hours from
Right.
today.
He's served all of his time.
Right.
Okay.
Yeah, there was
Cool.
a credit for time served. So he will be out within 24 hours. And I usually say that, like I did on the other case, they should report to whatever program is set up for them within 24 hours of their release.
Definitely. Thank you.
All right, thank you.
Position 4,
Thank you, sir.
Mr. Bill. Mr. Bell.
Okay,
And Your Honor, this will be a waiver of arraignment, and we'll be entering a not guilty plea.
okay. All right, that will resolve case number 23 CR 002482F with Timothy Beal. So arraignment has been waived. Your not guilty plea is entered. It'll be further notice for trial.
Thank you, ma'am.
All right, thank you.
Next, Your Honor, we're gonna go with position number 17, Mr. Hughley.
Okay. Let's see. Is this a negotiated plea?
It is, Your Honor. It's simply a time served, balance suspended, stay away situation. So it should
Okay.
be rather simple.
Okay. All right, this is 23 CR 002480C. Is it La Francia? La Francais Hughley, charge of 1 count of criminal trespass. State?
Yes, this state's recommendation is 12 months to serve 30 days, credit for time served 15 days, and balance suspended, and to stay away from the Exxon gas station at 1959 Lakewood Avenue.
Okay, is that your understanding, Mr. McLean?
Yes, Your Honor, it is. And he
Okay.
does stipulate to the three necessary elements.
All right. Mr. Hughley, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, and put your hand down. Ask you a couple of questions here. The first one being, are you presently under the influence of any medication, drugs, or alcohol?
No.
All right, are you satisfied with the services and representation of your attorney?
Yes.
And are, excuse me, do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
You're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And are you prepared and agree to waive these rights today?
Yes.
Has anyone told you receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And do you understand that if you're presently on probation, your probation could be affected by your guilty plea today?
Yes.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes.
And so as to the charge of criminal trespass, how do you plead?
Yes.
All right, I will accept your guilty plea. And your probation will be suspended, and you are to stay away from that Exxon station at 1959 Lakewood Avenue, then we won't see you again.
Okay.
All right, good luck to you.
That's right. Good luck. Good to meet you.
Okay.
Next, Your Honor, we have position number 3, Mr. Azizi. Oh, no, you go to 3 South. You go to 3
Oh,
South
okay.
one.
Okay,
Position 13.
13. Okay.
Mr. Fleming.
Let's see. 13, is that a negotiated plea?
Fleming, Your Honor, 13.
Yes.
Yes, that is correct, Your Honor. It's a negotiated plea. It's a 1-count case.
All right, this is 23 CR 002477G. Mr. Fleming, you're charged with 1 count of battery. And that offense date is February 22nd, 2021. State?
Yes, the state's recommendation is 12 months to serve 30 days. Credit for time served 15 days. The balance probated to a 12-week anger management course and no further contact with Mr. Malik Anderson, and to stay away from the incident location, which is 156 Forsyth Street.
Okay. Mr. McLean?
Yes, Your Honor, he does wish to ask the court to accept his negotiated plea of guilty under those terms, under the stipulations where he stipulates to identification, venue, and factual basis. And Your Honor, he understands about the 12 weeks anger management. We would ask the court to give him any consideration it can towards making it non-reporting perhaps after he completes the course. The course will cost him, it's about half the cost. It's 12 is more than we often do, not always, but it'll cost him about half of what a FVIP costs. So it's going to be like several $100, maybe about $500-600 to get through those 12 hours. We would ask the court to consider that.
All right, I will order that he can go non-reporting after completion of the 12-week anger management course.
Thank you.
All right, ready to take your plea, Mr. Fleming?
Yes, ma'am.
South, okay. Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
Okay. You may want to come a little closer. I know you've got a lot of background noise there if you can. Okay. I'm going to ask you a series of questions. Did you stipulate, Mr. McLean?
We did stipulate, Your Honor, that we all.
Okay. All right. Let me ask you first, are you presently under the influence of any medication, drugs, or alcohol?
No.
Are you satisfied with the services and representation of your attorney?
Yes.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
And has anyone told you that you'll receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And do you understand that if you're currently on probation, your probation could be revoked or affected by this guilty plea here today?
Yes.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes.
And as to the charge of 1 count of battery, how do you plead?
Yes.
All right, I will accept your guilty plea, and you understand you have to take that 12-week anger management course and stay away from Malik Anderson and 156 Forsyth Street.
Yes.
Is that clear?
Yes, ma'am.
All right. Thank you. That will complete your case.
Next, Your Honor, we have position number 3, Mr. Azizi Accord.
All right. This is 23 CR 002476E, Mr. Accord. Let's see. Is this going to be a negotiated plea?
It might be non-negotiated. Our only issue is it's a stay away. We would ask for a stay away unless a valid medical reason. It is a outpatient behavioral health treatment center, and it's where Mr. Accord goes to get his medication. And I haven't heard back from Mr. Walker on if that's okay.
Okay. Mr. Walker.
I'm sorry, Your Honor, I was on the phone with the victim. What position is this?
This is position 3, Mr. Accord.
Okay, 1 second.
Mm-hmm.
Oh, was this the request that can he return if he's getting medical treatment?
Correct, yeah.
Oh, yeah, that's not an issue at all.
Right, I
Okay.
just wanted to make sure, yeah. And I will also note it looks like the spirit of the offer was for time served. Mr. Accord only has 15 days. So instead of serving 32 days, we just asked to word it as serve 30.
That's fine.
All right. And balance suspended and that stay away is from this.
Behavioral health
Outpatient.
center. Yes,
Okay.
and I can give the court the address in 1 second.
Okay.
But yes, the state's offers only 12 months to serve, 30 days, credit for time served, 15 days, balance suspended with the condition of a stay away of the behavioral health center. And I will have that address in just 2 seconds.
Mm-hmm.
And I have 10 Park Place South.
Oh, yeah, that is it. Thank you, Mr. Dodes. 10 Park Place South.
Okay. All right. Mr. Accord, are you ready to take your plea?
Yes, Your Honor.
Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right. Did you stipulate for me, Mr. Dodes?
Yes, Your Honor, we do stipulate to the 3 elements, factual basis, venue, and ID for the purpose of this plea.
All right. And I'll ask you a series of questions that you've probably been hearing all morning. The first one being, are you under the influence of any medication, drugs, or alcohol?
No, Your Honor.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, Your Honor.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, Your Honor.
That you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes, Your Honor.
And are you prepared to agree to waive these rights today?
Yes, ma'am.
And has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, Your Honor.
And do you understand that if you are currently on probation, your probation could be revoked or affected by this guilty plea today?
Yes, Your Honor.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am. Will you?
And as to the charge of criminal trespass, how do you plead?
Plead guilty.
All right. I will accept your guilty plea. And again, you're to stay away from 10 Park Place South unless you're receiving treatment there.
Yes, ma'am.
Outpatient treatment, okay?
Yes, ma'am.
All right, good luck to you.
Thank you, Mr. Anderson. Thank you.
Mhm.
Next, we have position 11 and position number 12, Mr. Brandon Denton.
Okay. All right, let's see what we have. Is this going to be a negotiated plea and a no pros?
That is correct, Your Honor.
Okay. First case, 22 CR 0065558D, Brandon Denton, charged with 1 count of criminal trespass, 2nd count of willful obstruction of a law enforcement officer, Penn State 9/26/2022 state.
Yes, Your Honor. The state's recommendation is going to be 12 months to serve, 28 days, credit for time served of 14 days. Balance suspended with the condition of a stay away from the BP gas station located at 343 Joseph E. Lowry Boulevard.
Okay. Is that your understanding, Mr. Dotis?
That is our understanding, and we do stipulate to the factual basis, venue, and ID for the purpose of this plea.
All right. And Mr. Denton, can you raise your right hand for me? Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury? All right. And let me ask you a few questions. Are you presently under the influence of any medication, drugs, or alcohol? Do you understand that are you satisfied with the services and representation of your attorney? And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence? Can you hear me?
Make sure you speak up in the mic.
Okay. So do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
And that you're giving up or waiving the right to remain silent and not testify against yourself? And that you're giving up or waiving the right to trial by judge or jury, whichever you prefer? And are you prepared and agree to waive these rights today? And has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am.
All right, has anyone promised you anything to plead guilty? And so do you understand that if you're presently on probation, your probation could be revoked or affected by the guilty plea? And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you? All right, and as to the charge of criminal trespass and willful instruction to those 2 charges, how do you plead? Say that again. How do you plead?
Guilty.
Okay. All right. Thank you. We'll accept your guilty plea. The balance of probation is suspended as long as you stay away from the BP gas station on Joseph E. Lowry. Okay. All right.
Position 7.
And Your Honor,
Mr. Brown?
I was unable to interview Mr. Brown. I would need a breakout room with my laptop, PD, Angelo Dotis, and jail court's iPhone to speak with Mr. Brown.
Did you hear that, Miss Grace?
Yes, ma'am.
gotta put you on hold. I gotta get praised over, right? I'm sorry. Here we go.
Your Honor, while they're going into a breakout, we can go to position number 30, Mr. Ricky Williams. He's
Okay.
the client.
Your Honor, yesterday I was honored to meet Mr. Williams and convey to him the state's offer. He was going to think about that overnight. I'm not sure he had an understanding. I wanted to make sure that he had an understanding of what he was charged with and what the plea bargain offer was. Mr. Williams, are you feeling well today?
Yes, sir.
Do you understand what you're charged with?
Yes, sir.
Do you understand what the plea bargain offer is from the state?
Yes, sir.
And this is a thing where the state is offering on the jail portion of your sentence time served. On the rest of your sentence, also referred to as the balance, it would be a suspended sentence. And you would be required to stay away from the MARTA station, which is Oakland Station on Lee Street.
Yes, sir.
So I think we have an understanding, Your Honor. He did need to think about that overnight. And I wanted to make sure that he was completely understanding.
Okay.
What, do you wish to plead guilty or not guilty today?
Yeah, I plead guilty today.
Do you understand the conditions under which you would have to stay away from the MARTA station?
Okay.
This would be a suspended sentence, Your Honor, if he offers that. So I believe he's pleading guilty today under the terms of the negotiated plea.
All right.
We would stipulate to venue, identification, and factual basis, and ask the court to accept the terms that the state announces.
All right. Anything else, ASG Bickerstaff?
Nothing else, Your Honor.
Okay.
We should
All
say
right.
that the jail portion of the sentence would be, the jail part would be time served in effect, because the state was offering him 12 months to serve 34 days, credit for time served of 17 days.
Okay. All right, Mr. Williams,
Yes.
raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. And in order to accept your guilty plea, I'm going to ask you a series of questions. Are you presently under the influence of any drugs, medication, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty today, you're giving up or waiving your right to the presumption of innocence?
Yes, ma'am.
And do you understand that you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you are prepared and agree to waive those rights today, is that correct?
Yes, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
Has anyone told you that you receive a lesser sentence for pleading guilty?
No, ma'am.
All right. And if you're presently on probation, you understand that your probation may be terminated or affected by a guilty plea here today.
Yes, ma'am.
And do you understand, again, that you're giving this guilty plea freely and voluntarily with the full understanding of the charges against you? Or the charge against you, one charge? Hello? So let me ask you that again. Do you offer this guilty plea freely and voluntarily with a full understanding of the charge against you?
Yes, ma'am.
Okay. All right. And so I will accept your plea to criminal trespass. How do you plead?
Guilty.
All right. That will be good. And you understand your conditions, correct?
Yes.
All right. Balance is suspended as long as you stay away from the Oakland MARTA station.
Okay, so when will I be released? Tomorrow?
24 hours, they
Don't
will
have any
process you.
Yeah, okay. If you don't have any holds, be 24, 48 hours perhaps. That is
Okay.
30, yeah.
All right, good luck to you.
I believe we're ready on position 7. If you're up there, okay.
Mr. Dotis,
Yes.
you hear me?
You're breaking up.
I got a medical,
We heard a part of that.
okay, we have to medical reset Mr. Brown, position 7.
Okay. Will be reset till tomorrow.
Yeah, did you mean next Tuesday?
Oh, I'm sorry. You know what I'm thinking about, don't you?
See calendar.
So to next Tuesday, which is that the 9th, Ms. Grace?
Let me check right now, Judge.
Okay.
My name's McLean, but I just do the SAT calendar. Mr. Howard, his name is Garrett, not Howard. His first name is Garrett.
That's fine.
Okay. It'll be reset to next Tuesday, the 9th.
Thank you.
All right, thank you.
Thanks, Duffy. Next, Your Honor, we have Ms. McLeod's client, position 20, and position 21, Mr. Eddie Person.
Okay.
Good morning, Your Honor.
Good morning. How are you?
I am well. Thank you for asking.
All right, we have Mr. Eddie, is it Person?
Yes, Your Honor.
And that is 23 CR 0024770B. And I think he's 20 and 21.
Yes, Your Honor.
And then 21 is 23 CR 0024772B. Both are battery family violence cases. The first with the offense date on February 28, 2023. The second, April the 19th, 2023. And are these both pleas, or what are we doing, Ms. McLeod?
No, Your Honor. We need to address the issue of my client's mom. There is an offer on one of his cases, but there's no offer on the other case at all. So essentially, he's just sitting in jail. He has cash bonds, total of $3,000 cash bonds on his case, Your Honor. My client is disabled and has been disabled for some time. He denies that he was the aggressor in either of those 2 instances with this alleged victim, Your Honor. And he tells me that he has staples in his head from where she actually attacked him. Sitting in jail is not good for him, considering his disability, and he really is in no position to pay a cash bond at this time, Your Honor. So I would ask the court to revisit his bond.
So is it, tell me what it is on each of the cases.
It's $1,500 cash on each, Your Honor.
All right. Pre-trial.
Sorry, Your Honor. It looks like the defendant, Mr. Person, he has 41 arrest cycles beginning in 1985. Within the last 10 years, it looks like he only has 1 misdemeanor conviction for driving while license suspended from March of 2014 and 1 FTA. And that's just within the last 10 years.
All right. How old is he, Miss McLeod?
I believe he's 53, Your Honor.
56, ma'am.
56, I'm sorry. I had him 3 years younger, 56.
All right. State?
Yes, Your Honor. So for position 20, well, for both positions, the victim is the same, Ms. Kendra Barnes. And position 20, that incident happened on February 28, 2023, where the defendant and Ms. Kendra Barnes got into an argument over toilet paper, and the defendant aggressively pulled her shoulder, causing bruising. And then in position 21 happened at the same location at 1080 Regent Street. And this is where Ms. Barnes told police officers that the defendant had been drinking all day and he was getting into verbal disputes with other people that day. And that's where the defendant grabbed Ms. Kendra Barnes' clothes and put them outside. And so when he grabbed her clothes, she tried to stop him. And that's when the defendant grabbed her by the neck, grabbed her by the back of her neck, and her hand, and he caused the laceration to her neck. There was an independent witness listed in the warrant, Miss Carrie or Carrie Harden. And Harden told the officers that the defendant was drinking all day and he was fighting with Miss Barnes. The defendant, Mr. or Mrs. Harden said that Ms. Barnes was trying to defend herself. And so she had grabbed a fire extinguisher and hit the defendant in order to protect herself. And so for those reasons, for position 20, the state's recommendation is 12 months to serve 60 days, credit for time served 15 days, the balance probated to an FBIB, and no further contact with Ms. Kendra Barnes, as well as an ADET, and to stay away from the incident location, 1080 Regent Street. And then for position 21, we are not offering anything.
Your
All
Honor,
right, I believe that's what Ms. McLeod told me.
yes, Your Honor.
Anything else,
I
Ms.
just
McLeod?
wanted to add that the Regent Street address is my client's home. This is his home.
And do we have a different address with the victim?
No,
They
Your
live
Honor.
together and they share a child.
But not together, Your Honor. I allowed him to come to my home because he had nowhere to live at. I do have compassion in my heart because we share a child together. We have been together for 20 years, but she has nowhere to go. And she popped up my house. My cousin brought her to my house. She just came to my house and asked. So she asked me to stay for about a week. I do it. It happens every time. I get her in my home to try to help her out, keep her out of the streets, keep her out of harm's way. And she just misused me. And Mr. Carey actually, the officer is lying because Mr. Carey told her that she actually hit him with a fire extinguisher for no reason.
Right. How old is the child you share together?
He's 34, he's 33 years old. He's a grown man.
Oh, okay. Not a
Life.
minor.
That's the only child. That's the only child I have in life. And I have grandchildren, and that's why I have compassion in my heart for her.
All right, Mr. Person, I think the judge gets the picture now.
And just for a couple points of clarity, there's no offer on the second case because, as you know, your second battery family violence is a felony. So if he were in theory to plead to the first one, the second one would be a DA transfer. So that's why there's not an offer on the second case, because potentially that could be a felony. And as far as them living together, whether it's his home, like the defendant stated, they've been together for 20 years, they share a child. Once you reside at a location for more than 30 days, you become a tenant at will. So at this point, it's their home. So that's where the victim resides. That's her legal address. And we're asking that the bond remains the same.
Excuse me, Your Honor. I did not say.
Mr. Person, this is just your bond hearing. We're not trying.
I did not say we've been together for the last 20 years. We haven't been together for 20 years. She's not my female. We're not sleeping together or anything.
Mr. Person.
Mr. Person, your attorney is telling you to be quiet, please. Okay, this is not your trial. And so he's disabled and he's been in jail since when?
He's been in jail, I think, since around April 15, I believe. April 15 or 16.
Was that what you have, State?
I have 15 days. Let me look up today makes 15 days in jail.
I'm showing since April the 20th, Judge.
Okay.
I think he told me he had been arrested before and sitting there before.
Oh, okay.
Yes.
And what about other family or relatives of Mr. Person? Do we know about that, Ms. McLeod?
Your Honor, he doesn't have any other family members that he can stay with because I asked him about that.
You have quite a bit of history, however, in the last 10 years, don't have as much. And I'm just concerned in making sure, Mr. Person, that you will return to court.
I will return to court, Your Honor.
Your Honor is a lifelong resident of Atlanta. He tells me that he will return to court. He, as the court noted, he doesn't have any significant history in the past 10 years. He is 56 years old.
All right. I will grant, I know it's a $1,500 cash bond because of two cases being relatively, what, 2 months apart? One in
Yes, Your Honor.
February, and one in April.
Against the same victim.
Against the same victim. I'm sure that's, did I order the 1,500 cash? Was it me?
I don't think
I don't know
so.
if it was me or not.
I believe it was Judge Law.
Yes.
Judge Law.
It was Judge Law.
Well, what I'm going to do, Mr. Person, if I go ahead and give you a signature bond to get out, you will still have to go live somewhere else.
It's okay, I go to my father's house.
I'm sorry?
I go to my father's house. I actually need to go get my security deed from my home. That way I can get a eviction. That's the police said. Police.
I think he needs a one-time police escort back to the location, Your Honor, to get his things.
All right, I'm going on the first case, position 20, ending in 2470B. I'm gonna give a $2,000 signature bond through the jail.
Your Honor, excuse me, I'm sorry. Pretrial just chatted me some new information that she found that the defendant has a 2019
see.
act assault. Okay.
I see it now too. I don't know if you're aware, Ms. McLeod, he's got a felony hold, so he's not going anywhere.
Excuse me, ma'am. That case was cleared up. I went to Zoom on that case. I do not
Ms.
have a
McLeod
hold.
can check on it, but they're not showing it.
That one
Trial
as
is
well
telling
as
me.
a,
I didn't see that when I looked.
I went on Zoom and I was taken care of.
These open cases.
It's not open.
Mr. Person, let Ms. McLeod represent you.
Yes, ma'am.
Okay, go ahead, Ms. McLeod.
Yes, I did not see that he had an open felony cases when I looked at his open cases on Odyssey.
also, there's a 2019, well, the case was no pros, but I think it's good for you to know, Your Honor, the defendant had a 2019 ag assault against the same victim. However, it was no pros, but still, that's concerning.
Can I say one thing, Your Honor?
And so we still see the hold, Mr. Jordan. They're saying you have a hold. Give your attorney a second. Let her look as well.
Your Honor, I'm unable to see things like that. I can only see whether he has open cases or not when I look in Odyssey.
Your Honor, I don't see any hold on this
Yeah,
side.
Your Honor, I checked, this is Officer Norris, I checked the jail, honestly, and I don't see a hold on him either.
No hold.
Yep, it just looks like these two cases with the cash bonds that are holding him.
Okay.
And Your Honor, I'm showing, now that I've looked, I'm showing an open simple battery case that he's currently already out on bond for as well. That's 22 CR 002963F. That is a different victim, but obviously it looks like the defendant has a propensity for violence. I'm hearing that he had a previous ag assault with the same victim. He has 2 open battery family violence with the same victim, and then we have an open simple battery.
Right, I think it's
That's
getting
it.
worse. The more we talk about it, the worse it gets.
And I'm sure that's why Judge Law probably issued the cash bond. I understand that the defendant is saying that he was disabled. I understand these are allegations, but he wasn't too disabled when these altercations occurred. So we're asking that the bond remains as set.
I see. And I see
Mr.
Judge Law
Walker.
come on.
Mr. Walker, these are still just allegations.
That's
As
They're
you
quite-
well
they're
know,
quite
I'm
serious.
sure.
It-
Right, they're quite
allegations
serious with the
sometimes-
same victim.
I understand, Your Honor, but sometimes the allegations and what turns out to be the fact just don't line up.
Right. Judge
Sure.
Law, good morning. You're muted. You're muted, Judge Law. Judge Law, we can't hear you.
May I interject? This has nothing to
Yes.
do with the case you are addressing. I
Oh.
have a lady here in the courtroom who has to appear via Zoom for the motion to set aside a bench warrant, domestic violence. She is absolutely incapable of using Zoom. So her name is Monica Simpson. So I'm going to send her to the clerk's office to see if they can assist her with coming on to address the motion to set aside.
Well, your ears must have been burning because we were talking about you.
All great things.
All
Oh,
great,
thank you, Mr.
exactly.
Walker.
It was all great. And that's what I thought. Oh, Judge Law must know that we mentioned her name and she's coming on to help us out.
No, unfortunately, no. So yeah, I heard all the compliments about me beforehand, but so I just want to let you know that I'm going to direct Ms. Simmons to the clerk's office so that she will
Okay.
make a timely appearance for the bench warrant hearing. Okay.
Right. And when she
All right.
goes there, just tell her to let Miss Grace, she'll send us a message in the chat and we can handle her matter.
Okay. All
Okay,
right.
thank you, Judge.
Have-
Appreciate it.
okay.
All right, bye-bye. Yeah, I thought she was coming on to say, yes, I remember that case. But, and we normally do not do that, but I just thought it was very coincidental. But I am concerned, let me go back to you, Mr. Person. We've got 2 cases, and these are all very recent in the last year or so. And the more we sit here and discuss your matters, I hate to say it, the worse it gets, meaning the more concerned I am for these victims. So,
One thing, can I say one thing? And
Mr. Person,
I'm saying, okay.
so I'm going to retract my signature bond. And what I'll do on each of the cases is lower it to $1,000. I'm sorry, $1,500 surety bond on each. I will do that, but I will not give you a signature bond.
thank you, Your Honor.
All right, 1,500 surety bond on both.
All right, can I come? Let me come.
Thank you.
Is that it, ma'am?
All right.
Next, Your Honor, we have position 14, position 15, position 16, Mr. Hunter Hewitt.
Okay. 14. Mr. Hewitt.
Your Honor,
Oh, he's 14 and 16.
14,
No, 14,
15,
15, 16.
and 16. yeah.
Gotcha. 3 cases. Yes, yes, sir.
Your Honor, these are 3 theft by receiving cases. What we'd like to do is waive formal reading of each accusation and have the court simply tell them that they are misdemeanors that carry the maximum punishment of 12 months and or $1,000 fine.
Okay.
That he needs to watch out for his future court dates. And I will certainly inform his other lawyer to coordinate as much as possible and to watch out for him. We'd like this to go on to the trial court.
All right. Mr. Hewitt? You are being formally arraigned on all three cases, one ending in 1442Y, the other ending in 2491Y, and the third one ending in 493Y. Looks like there are three theft by receiving stolen property cases. And the Solicitor General has already accused these cases of those offenses brought against you. Just want to let you know that each of those cases carries the maximum prison sentence of 1 year incarceration, as well as a $1,000 fine. And your cases will be further noticed for trial.
Yes,
All
ma'am.
right.
Yes, ma'am.
All right. Thank
And
you.
Your Honor, he pleads not guilty to each of those three.
And we accept your plea of not guilty on each of the three cases.
Thank you, Your Honor.
All right. Thank you.
Your Honor, I have an announcement on the case involving Miss Addie Rogers.
Let's see. Is that on the SAP or that's on the other? Let's see.
I think we're talking about 2223.
Oh, okay. 22 and 23. Okay.
Your Honor, this individual is living at a transition home and has the director of the transition home I was able to get a hold of, been trying, and voicemail was full, but anyway, I got through. She picked up and she described to me the diagnosis and medication list. Instead of not guilty, this should be referred to an incompetency calendar, and then coordination should be done. As long as this person's on med, she's great. So if we could just put that over to the competency calendar as soon as possible.
Okay. Miss Grace, what will that do? Or Miss Champion? I'm not sure if I'm calling out the wrong names.
Judge, we can put it out for June the 1st. And he need to do the evaluation, send that in. Let's see. Yeah, around June the 1st. That's about 3 weeks out. Yes.
All right. So this is gonna be MHET.
Mr. Howard is here in the courtroom. If I can consult with him a minute, because
Okay.
I'd like to find out if there's any way to do something faster for her, but if I can report back in just a few minutes to the court on that.
Okay. And did you get that, Miss Grace, that DV bench warrant Monica Simpson is there at the courthouse?
Yes, ma'am. Mr. Jordan is handling it now.
Great. All right. Thank you.
So when you're ready to talk.
Oh, yes, go ahead, Mr. Jordan.
Oh, are you ready for her case, Judge?
Well, let's see. I was going to do it real quick. Go ahead while they're talking.
Oh, no, she's good. I was just showing her how to use the Zoom.
Because that's the only case we have on the DV bench warrant, right? Just the one?
That's correct, Your Honor.
And I was going to squeeze that in real quick since she's there at the courthouse. If you all don't mind. Mr. Jordan,
Oh, I'm sorry, Judge. Were you ready for this case?
yes.
Okay.
And this is your case, Ms. Bickerstaff? Good morning, Ms. Simpson. Your case number is 22 CR 001450G. One count of simple battery family violence. The offense date is March 15, 2022. ASG Bickerstaff.
Yes, Your Honor. So this incident occurred March 15, 2022. And this is where officers arrived to 150 Peyton Place. And this is where the defendant and a Mr. Stokes got into a physical altercation where the defendant pushed Mr. Stokes and he decided to push her back forcefully. However, Mr. Stokes didn't have any injuries. Both Mr. Stokes and the defendant were arrested in this altercation, Your Honor.
All right, and do we have a court date or something that Ms. Simpson did not appear?
Yes, so let me see. So I see that there was a bond forfeiture set aside on 9/28/22, and the reset notice was sent out on 4/27/23 at the updated address.
No, ma'am.
Ms. Simpson, Ms. Simpson, let me talk, let me speak for you, okay? We spoke yesterday, just let me talk, okay? We're gonna let Ms. Bickerstaff say what she needs to say at this point.
All right. Yes, hold on, Ms. Simpson. Go ahead, Ms. Bickerstaff.
Yes, so that's what I'm seeing right now, yeah. And the updated address is 52 Riverside Court. Yeah.
No.
Hold on, Ms. Simpson, just let me.
All right, go ahead, Mr. Dotis.
Yes, Your Honor, I guess I didn't hear a recommendation from Ms. Bickerstaff. Are they?
Well,
Okay.
we're not looking to remove the bench warrant.
Okay, understood, thank you.
Mhm.
Yes, Your Honor, I'm not going to get into the facts of this case because this is just for the DV bench warrant calendar. She was given a $5,000 surety bond on this case and she was able to bond out. Since then, she hasn't picked up any new charges. On the address was mistakenly originally listed, I believe, as the incident location. I'm not going to say any addresses, but I'm happy to type them in on chat. She abided by the no contact with the alleged victim and she abided by the stay away, so she wasn't able to get her mail. In September September 28th of 2022, when she learned that her mail was going to an address that she wasn't getting her mail at because she had to stay away, she did update her address. And you can see that updated address if you click the 9/28/2022 reset document on Odyssey. For whatever reason, her mail kept going to the original address. And so you can, if you look at the return to sender sent April 28th, 2023, that's getting sent to the wrong address, even though she updated her address with the court. That's why she missed court. And if you click, when I go to defendant demographics on Odyssey, it looks like that bad address is still listed as the current address in the correspondence address, when that updated address that she provided, that I will provide in the chat, needs to be the correspondence address. I'm not sure why that didn't happen, but that's why she's missed these two court dates. She is here, and I would note that she wanted to make sure that she didn't miss this. She came in person because she didn't want any technical issues to hold her back and make sure that she could appear. Again, this was set aside. There was no issues in September because of the issue, and now it's the same issue with just the mail going to the wrong address through no fault of her own. Again, she updated her address, so we would just ask for this to be set aside and confirm that Odyssey will update her correspondence address. Because if you look in And Mr. Walker, Ms. Bickerstaff, if you look in the,
I see it, Mr. Dodes.
okay.
The only thing I can say is Mr. Jordan. No. No, she did. I see that she did update her address and they still sent it to her previous address. So obviously I can't explain that.
All roads lead back to Mr. Jordan.
Mr. Jordan, you're on the hot seat.
But neither here nor there will consent to this one time because I do see that it was sent to her old address. I don't know. We need to confirm with the clerk's office that they have the updated address. I see that she did do a change of address form.
Okay, Judge, I'm back in my seat.
You're back in the seat. Okay.
So I'm not sure what happened. There was a change of address done on 9/28/22, and there was a 52 River Crest Court put on there. I'm not sure if that is her current address.
Right,
But for
that's,
some reason, say again.
that is the updated address. I just want to confirm.
Okay.
So I'm not sure why the notice was printed and went to her old address. It did show that the notice went to the old address on that April calendar. I'm looking
Okay.
now, it printed for her old address, but her current address is showing in the system.
Okay.
I think I know what this is. So someone changed the current known address, but they didn't check the correspondence address, but I got it checked now. So that'll solve that.
All right. But I will remove the bench warrant.
Thank you.
And it looks like that just might have been slightly a technical issue with that. Just continue to keep in contact with your attorney and make sure if you move again, we do what you did before, is do the updated change of address form. Okay.
Thank you,
Yes,
Your Honor.
ma'am.
Ms.
All right.
Simpson,
Thank you.
Ms. Simpson,
That
if you have any questions, please reach out to me. And Your Honor, I will submit that set aside as soon as I leave the court building.
Okay. Thank you.
I say anything with that?
Yes, you're released. Thank you.
Okay, thank you.
Uh-huh.
Bye-bye.
Bye-bye.
Okay.
Your Honor, we're gonna go to position 26 through 29, Mr. Willie Taylor. It's 26 through 29.
Okay. Hey, excuse me. Can you take this off Zoom? I'm finished. I don't hear this home in here.
Yeah. All right. This is positions 26 through 29. 20 CR 0057774C, Willie Taylor, charged with 1 count of battery family violence, 4/26/2019. Second case ending in 5775C, 1 count of battery family violence, and the second count of simple battery family violence. And then position 28 is an FTA ending in 0345 from 3/10/23. And then position 29 is another FTA 0346 from 3/10/2023. What are we doing with these cases today?
Your Honor, I'm in between bouncing back and forth on the phone, getting hold of Ms. Rogers, Director of the Transition House. I had been also bouncing back on the phone with an investigator in our office. And in the case of 26 and 27, which are the basis for the FTA in March of 28-29, he says he did not get a letter. He did not intentionally miss court on 3/10/23 for these two cases from the 2019 year. Your Honor, in the cases for the 2019 year, the alleged victim is Marie Clemens. Ms. Marie Clemens was an acquaintance of Mr. Taylor, but the family violence would not be appropriate as an accusation. However, the point is that she is deceased. He heard on the phone. They, I think, lived in the same town or They knew people that knew people in the past, and he heard on the phone that around, it was December the 17th roughly, that she was in Union City, and he got a call from a niece of her daughter, I'm sorry, that she was deceased, and that was very sad news. But Your Honor, I've been trying to get my investigator to track down a death certificate for Fulton County, we believe it is, from this mid-December, perhaps the 17th of last fall, just a few months ago, that she died. And he works at Train. He works for Randstad Temporary Staffing as a forklift operator. He's worked for Train before in the past, and right now he's working at a Train warehouse. His boss is named Leonard, but I didn't catch the last name. I'm sorry, I did not have time to research that aspect and call Leonard at Randstad or at Train to confirm his employment. He has been in Atlanta for quite a few decades. He is born in 1966. I'm trying to calculate his age. I'm not much better. 56 years old, and he's a forklift operator, Your Honor. He lives in that Roosevelt Highway area, and his cousin is Polly Binion, with whom he will make sure, if the court were to allow him to be out, that he uses her mail address and will never, ever miss court again. I think the case ultimately might be heading for dismissal because of the reasons that I've been talking about. But Your Honor, Polly Binion, his cousin, is this the address you were giving me? 515 Jonesboro Road. It's a house.
Usually Georgia, don't want to see my mail there.
And if he gets his mail at 5015 Jonesboro Road, he believes that he will always be in touch. Now, I have the opportunity today, Your Honor, to give him a lecture. I give quite a few of my clients about don't rely upon the mail for your freedom. Good, just go down to the courthouse every 2 weeks and look on the public computer and look your name up. You'll never miss court. It's impossible to miss court if you do that.
Yeah. That's what we usually advise, to check in with the clerk of the court.
But they have a public computer on the counter, so you don't even have to bother them at the glass window. You don't need to call them. You just go down there every 2 or 3 weeks, and it's impossible to miss court if you do that method. And I'm giving him the lecture about that today.
All right. State?
Yes, Your Honor. So we talked to Mr. McLean, and we said that we will allow some more time to reset this so he could get the death certificate. So we can reset till next Tuesday? Is that good, Mr. McLean?
Right, and he's you can speak.
Your Honor.
He wants to speak.
Your Honor.
Uh-huh.
The reason I missed court, I moved all this happened in 2019. I moved, I stayed in a hotel, I have 2 boys, 15, 14, it'll be 15 tomorrow and 12. I stay in a hotel, I've been staying in a hotel for the last 4 or 5 months. I'm paying $85 a day. This lady who keeping my kid now, she done had a stroke, she's 62 years old. My son got suspended. I've been in jail for 15 days. And I was wondering, that's all, I mean, I would show up to court. I never miss court. I just didn't get a letter. I just need to get home to my family and go to work. I'm staying in a hotel later. Oh, I would show up to court. I promise I don't miss court. I never been in no more trouble since then. And this female, she passed away. I was a pallbearer at her funeral. She passed away December the 17th, 2022. I haven't been in no trouble. I don't do anything. And
Mr. McLean, how close are you to getting the death certificate? Sometimes, at least I'd see this happen last year, but
Your Honor, I'm just now hearing these pallbearer funeral. I might can get something on the internet about the funeral itself if I find out what the funeral home was. Your Honor, my regular investigator is out on family leave because of a family emergency, so I've been talking to one of the other investigators who's who's trying to track it down as we speak. We just don't have the death certificate yet. Told him about this about an hour ago, and they're doing their best.
Right.
What was the funeral home?
I don't know the funeral home, but I got it on my phone, the video and everything where I was called there.
Yeah, but your phone's in your property.
And I did that, and my son got suspended from school since I've been in here. He's 14, got suspended, and this lady old, she can't watch it. I need to be there. I don't get in no trouble. I don't be doing anything. And like I said, I would show up for court. I would be there. I ain't never miss court. I'm a good guy. I don't do anything.
ASG Bickerstaff, do you have any history? Or should I ask?
I have 3 arrest cycles. Most recent is a DUI in 2015.
Okay.
I'm showing a 20, maybe it's the same DUI, but it was a conviction in 2019. But I'll just say this because it was a lot that was touched on. It is battery family violence. I reviewed the warrant. It said that they previously lived together, so that would make it battery family violence, Mr. McClain.
Never lived together.
Okay, well, I'm just telling you what's in the warrant. So that's why it's family violence. I do not know if the victim is deceased or not, but I will say in at least one of the cases, there's 2 independent witnesses. So just because the victim is deceased or possibly could be deceased does not mean that the case will be terminated or dismissed, as there are 2 independent witnesses for at least one of the cases. And the victim, I'm sorry, not the victim, but the defendant, in fact, has missed court. So that's not a true statement either. And that's all I have to say. I'm showing at least 2 FTAs. February of this year and March again of this year.
What do you say about those, Mr. McClain?
Well, Your Honor, I don't know what the address is that the February, March letters were sent to, but he does have a very stable situation. His cousin Polly's mailing address is extremely reliable, he says. I always have my clients rely upon the in-person method. You can't miss that way. So whatever we can say about the past, the future is bright on that. He says he just didn't get the letter.
That's it. I promise I ain't getting that. That's it. I show up, of course. I promise I didn't get it. I promise. I've been here for 15 days. You know.
What, Mr. Walker, what do we have for the present bonds?
Well, that's what I'm trying to look at now.
Were you thinking what I was thinking?
Well, I'm trying to see what the present bond is.
Okay.
Sorry. Got several screens open. So it looks like it's so there was bench warrants issued. One is a $2,500 surety, another is a $2,000 surety. So that in total for both cases would be a $4,500 surety.
Right, the booking sheet, the booking screen is apparently showing that $4,500 total. What's actually holding them in is the 2 FTA bonds just mentioned.
Correct. And I know at least one of his cases he FTA twice. Well, actually on both of his cases he FTA twice.
That was this year.
Right, that's that missed address letter, Your Honor. That's the return to sender we're talking about, just a month apart.
Well, I just clicked on the last case. Let me check again. I don't believe I saw a return to sender, so I'm not sure what you're speaking of.
Oh, I assumed it was return to sender if he didn't.
No, well, I just checked the case that ends in 774C. There is no return to sender. I'm checking the case that ends in 775C. I'm sure it was sent to the same address.
Right.
There's no return to sender to that on that case either. per Odyssey.
And that's exactly why, you know, the mail system is great and they're doing a great job, but as we're at the tail end of COVID, I tell people, don't ever rely upon US Mail, as great as they are, for your freedom. Just come down to the courthouse and check it out.
I'll come to court.
And with all due respect, Mr. McLean, that's why there's a conditional bond that you update the clerk of court with your latest address. So
right.
I mean, if you don't tell us where you reside, we can't get in touch with you.
I'm at 7410 Oakland Road now at a Colonel Lounge at the hotel I've been staying at for the past 3 months. And I've been different hotels because
Are you able to get mail there?
yes, ma'am, I'm able to get mail out now.
But you had not updated that address with the clerk though, correct?
Correct. I hadn't did that. I didn't know, ma'am. All my mail been going to 5015 Jonesboro Road, Union City, Georgia. That's where my cousin stayed. So that's where I kept it going there because I've been bouncing around.
Right, but your cousin didn't give you that important mail that you got from the
And
court.
my fiance went by there, well, my friend went by there the other day and she got 3 letters. She got 3 letters. There was no mail there from the court. I don't miss court, Your Honor. I promise I don't. I promise.
Well, I don't know that your troubles are over just because the victim has passed, as Mr. Walker said. You know, we want you to obviously keep your address updated with the court, and it needs to be an address where whoever your friend or relative is, that you're not going by once a month or once every 2 months to pick up mail. It needs to be much more often, every week or every other week. And again, Mr. McLean is teaching you how to check with the court as well, because these are very serious allegations. There's been an offer on one and not the other. And Mr. McLean probably knows why that is as well.
Right.
And when were you arrested?
15 days ago on the, I want to say the 19th or the 20th.
I have the 28th. Is it the 28th, Ms. Bickerstaff, or the 20th?
No, the 20th. I've been here 15 days.
One second.
I've got a booking number here and a booking date booked was April 20th.
April the 20th, 15 days, Judge.
Mhm.
That's what the booking screen is showing.
All right, so you have a new address that you're going to give us today, is that correct?
Yes, ma'am. Yes, ma'am.
I will give you one last chance. To set aside those 2 FDAs, and that's your last chance, last opportunity to get it together.
I'll be here, Your Honor. I promise I'll be here. I'll be here.
All right, so maybe find someone else on that mailing address if you're not going to use it to where you actually are located.
Yes, ma'am. Yes, ma'am. I'll be at court.
Okay.
And Your Honor, I know Mr. McLean knows this, but a change of address form has to be submitted to the clerk.
And filed.
Correct.
Mr. McLean, you may want to kind of give those out at some point. I know it's hard to when they're in jail, find a way to let them keep one as well.
Right.
All right.
I'll be on the computer in a minute, making sure of the address of the hotel, to which he's referring.
So I get released today?
24 hours.
Thank you so much, Your Honor. I promise I won't let you down. I'll be there. Thank you. Thank you.
So Judge, what are we doing with his cases? I'm confused.
I'm going to set them aside, both of the FTAs. And then the others, I imagine he's been arraigned on them. And those are.
I would think so by now, Your Honor, but.
You're right, because he had bonds.
Well, let me check. I'm not sure if he was arraigned.
Well, let's double check. I'm sorry. Yes, Mr. Walker.
He FTA twice, so I'm not even sure if he ever.
So he may not have. Yeah, that's.
Wouldn't hurt to check, right?
I may need to arrange him or arraign him on both of the cases.
Not yet. I'm up.
He needs to be arraigned, Your Honor.
Okay,
Yeah, we can waive the formal reading of the accusations, Your Honor.
all right. Mr. Taylor, on both of your cases of battery family violence, one ending in 5774 and the other one ending in 5775C, both of them ending in C. You're being formally arraigned, and notice that the Solicitor General's office has properly filed both cases, and they have filed their accusations in both cases. And you will be further noticed for trial. And again, you will keep your address updated in order to receive those notices. If you are convicted on both of those cases, each of them carries a maximum prison sentence of 1 year and or a $1,000 fine. And so that could run concurrent or consecutive, whichever way. The state has the burden of proof for those cases, and just letting you know what the maximum sentence and fine can be for each of those cases. All right, so you've been formally arraigned and notified.
Thank you, Your Honor. If they do end in C, so I'll tell them about how we do the nomenclature on cases and where he's going.
All right, thank you.
Okay, Mr. McLean, I'm gonna need the set aside so the judge can sign, please.
Very good. Thank you.
Thank you on the FTA.
Thank you. Thank you so much.
All right, good luck to you.
Good to meet you, sir. We'll get that for you.
Mr. Rogers, Miss Attorney McLean, are you ready for Miss Rogers?
What we're going to do is refer them. I'm going to talk with Mr. Howard. We're going to make a referral to the competency calendar. It looks like June is the first time they have a slot, but I'm going to talk with Mr. Howard about medications and whether or
Okay,
not.
she's right here.
Right.
Rachel, come have a seat and
Ms.
so you get it.
Rogers? Ms. Rogers, we're talking about a June reset date that they believe is the fastest they can do under current circumstances, but I'm going to gather some more information. I talked on the phone a little bit ago with the director of your program that you told me about. She did answer her phone. I've got her email. I'm going to give that to Mr. Howard. We're going to ask that this be handled in a way that would benefit you, and you'd be fine. But as quick as we can, we're going to try to get you out of here.
I understand why I'm being held.
I know. So I'm going to talk with Mr. Howard, who is on Zoom right now. I'm going to talk with him about, is there any way we can speed up the June court date or anything else we can do to speed that up? But we've got to get you, we got to get your records real quick, have some notion. Miss Christine was extremely helpful and very knowledgeable. She had a lot of facts and on her tip of her tongue about your situation.
I have a bond, $2,500. Can I pay the bond?
That is certainly an option.
I can't pay the bond.
If you have a bond right now, that's certainly an option. We're trying to get this done in a way where you can not have to expend any money, but we're trying to avoid delays.
Okay, I don't agree, sir, why I'm being held here. That's what I want to know. Because I have clothes, and one of my clothes is downstairs that I had on.
The facts of the case, we won't go into the facts of the case right now. Your Honor, our situation, she does have a bond, and she does have a place to stay, and I did speak with the director.
Well, then, Mike, we need to, maybe we can talk about that and see if we can expedite that process.
Right.
I don't know that we need to have her wait if we got somewhere for her to go. Mr. Walker, maybe you and I can talk about it after our next, the competency calendar.
Right.
Okay, well, my only concern is if June is the first court date available, I don't want her sitting there.
Right. That's why I'm saying you and I can talk maybe after the fee, see if we can do something sooner than that.
Mr. Howard, let me ask this, is it gonna be an evaluation done? Because you know that's mostly what the holdup is. We can try her for the 25th, but you know how those evaluations, the time.
Yeah, I need to talk with Mr. McLean a little bit more about it. I don't have, much information other than what I've just heard now. So,
okay.
Yeah. So
probably so. Based on the
hold
fact.
an announcement for that. Yeah.
Okay, I have some information for y'all.
Well, man, we'll get that from you off of the live stream.
No, this information concerning FBI.
Okay, do we want to hold her for today and discuss her on today's competency calendar?
Yeah,
That would be great. That would be a really good idea.
Yeah, let's talk about her after.
They're gonna come up with fees, okay?
Okay, that'll probably be best.
Yeah.
Next, we have, as Ms. Dawson come up, Attorney Howard. I spoke with an officer. They said that, your client refused to come out for medication or to get up for head count. So as soon as I finish, I'm gonna go down and check for you.
Okay. All right. Thanks.
All right. Here's Ms. Dalton. Hello.
So have we finished all of those on the SAP, Ms. Grace?
We have, Your Honor, position 10, Ms. Dalton for the ACDC.
You said all but 10?
That's my understanding, Your Honor, but I'll defer.
As in position 10, right?
Yes, I'm sorry.
I'm sorry.
That didn't come out right, did it? No, we don't have 10 cases left.
I hope not.
And is this Ms. Dalton?
Yes,
before me?
yes, ma'am.
Okay.
Yes, Your Honor.
Okay. This is 23 CR 00249OJ. Angela Dalton, one count of theft by taking. Is this going to be a plea or no?
Yes, Your Honor, this will be a negotiated plea.
Okay. All right. I understand, state, tell me what we have.
Yes, Your Honor. The state's recommendation is 12 months to serve, 28 days, credit for time served of 14 days, balance probated with the conditions of a BHET, a behavioral health evaluation, no further contact with the victim, whose name is, I'll give you his name momentarily, and to stay away from the incident location. That address is 27 Booker Street, Atlanta, Georgia. And the name of the victim is, I'm going to spell the first name, Biondi. Last name is Copeland.
Okay. All right, is that your understanding, Mr. Dodos?
Yes, Your Honor, that's our understanding of the offer, and we do stipulate to the factual basis, venue, and ID for the purpose of the plea. I would request if Ms. Dalton could go to non-reporting status upon completion of the evaluation and any recommended treatment. I would also ask this court to help Ms. Dalton land on her feet by waiving a few months of her probation fees so she can get back on her feet. I spoke with Ms. Dalton. She's clear on exactly what's required from BHET. She has all the phone numbers she needs, so she should be able to do that as soon as she's released.
All right, I will allow Ms. Dalton to go non-reporting when she has completed the BHET and any recommended treatment. Other than that, I cannot waive any fees right now. But hopefully going non-reporting will encourage her to complete that as soon as possible in any recommended treatment so that she can go non-reporting.
Thank you, Your Honor.
Okay. All right. Ms. Dalton, are you ready to take your plea at this time?
Yes, Your Honor.
All right, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, I'm going to ask you a series of questions. The first one being, are you presently under the influence of any medication, drugs, or alcohol?
No, ma'am. No, Your Honor.
Okay, are you satisfied with the services and representation of your attorney?
Yes, Your Honor.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, Your Honor.
And
Yes.
do you understand that you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, Your Honor.
And do you understand that you're giving up the right to trial by judge or jury, whichever you prefer?
Yes, Your Honor.
And do you understand that you are prepared and agree to waive these rights today? Is that correct?
Yes.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, just what y'all said.
Has anyone promised you anything to plead guilty?
No, they haven't.
Okay. Do you understand that if you are currently on probation, your probation may be revoked or affected by the guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
Okay, I will accept your plea. And as to theft by taking, how do you plead?
Guilty.
All right. And so
Okay.
you understand the conditions. You've got to get that BHET evaluation, any recommended treatment, no
Yes.
further contact with Beyonde Copeland,
Yes,
and stay away from 27 Booker Street.
Got it.
Okay,
Yes,
very
ma'am.
good. All right, good luck to you.
You too. Thank you.
Uh-huh.
I'm ready to talk.
Is that it, Miss Grace?
Yes.
I think. What happened on number 18? Maddox. I think I heard something.
I have that they were released.
Yes, we're done. He was released.
Okay, I thought so. Released. Okay. Do we have everything? Do we want to reconcile or not?
Yes, ma'am, that will be fine.
Okay.
Okay, position number 1 was reset jail jury, along with position number 2. Position number 3 was a plea. Position number 4, reset jail jury. Position number 5 was a plea. Number 6 was non-pros. Position number 7, reset 5-9 SAP. Position number 8 was a plea. Position number 9 and 10 were pleas, along with position number 11 was a plea. Position 12 was non-pros. Position 13 was a plea. Position 14, reset jail jury. Position 15, 16, reset jail jury. Position 17 was a plea. Position 18, reset further notice. Position 19 was a plea. Position 20 and 21, reset jail jury with amended bond orders. Position 23, position 22 and 23, we are holding on. Position 24, reset jail jury, along with 25, reset jail jury. Position 26, reset further notice, along with 27, 28, and 29. Position 30 was a plea. Position 31 was a plea.
Think we're good. Anything, Mr. Walker?
No, Your Honor.
And so we're holding on 22 and 23. Mr. Howard's going to help us.
Yes, and Your Honor, if we could, we need a new date for a probation revocation position, as well as addressing add-on 1 on the calendar, which is also going to be a 1-week request.
Oh, yeah, we didn't do add-on 1. Okay. Let's see.
And what's the last name?
Boyce, B-O-Y-C-E.
And was that gonna be a plea or?
That's
Yeah,
gonna
what
be,
is,
my apologies. That's gonna be a 1-week reset. I need to have a social worker speak.
Okay.
for us.
oh, reset. What say you, Miss Grace?
He said 1 week
If there's
for the 11th, Mr. Dotis. May the 11th.
Ms. Grace, that works for us. Thank you.
Okay, May 11th. All right, we
Mr.
ready for
Dotis, do
Mr.
you know the instant location for that case by chance?
For add-on 1,
Yeah,
I could pull it up.
no, I'm trying to pull it. Just 1 second, Your Honor. Okay. I'll submit a null price.
Okay.
Okay.
Next person, please.
Okay. Let's see. So now we're ready for Mr. Howard.
And Your Honor, do we have a reset date for that, for probation revocation positions 2 and 3?
All right, I'll ask Ms. Grace in second.
Would you like 1 week out or further, Mr. Dotis?
If we could do 1 week out, hopefully we can get him to appear from Oconee.
There he goes. Good afternoon, almost good afternoon, Mr. Howard. How are you?
Good, Judge. I didn't realize y'all were waiting on me. I was waiting on you. I'm
I was
sorry.
like, he might be on vacation again. I know he loves to go on vacation, but you've changed your background, so we can't tease you anymore. I like that. How are you?
Good, good. How are you?
Good. What you got for us today?
All right,
So-
we can go to breakout with
Yeah.
I guess
Okay.
Mr. Walker, Miss Burgess, and Miss Amin Williams.
And
Okay.
we can also add SG Victim Advocate G Maldonado to the breakout.
Oh, okay.
I have a client on the calendar as well.
Oh, you do?
And
Okay,
I
so
think-
you're back with us. I got you.
And Mr. Murphy, I think, has as well, Judge. So I guess he needs to be added. Yeah.
Okay.
So
She's bringing us in. Hold on, let me join.
Good morning. This is Miss Thomas. I stepped away. Is SAP over?
I think it is. If somebody else gets on probation, I'll let you know. If somebody takes a peek from that camera.
Okay, good. Oh, okay, they already went over the calendar?
I don't think they went over the calendar. They just went straight into the breakout room.
Okay, I just wait. All right, thank you.
Yeah.
Yep.